Want to try again on the last time you used methamphetamine?
I've struggled with daily use for a long time, Joe. So
What?
I've struggled with daily use for a long time. It's something I didn't know how to answer that question.
Judge, with his
I'm more
DA status, he's a honorably discharged veteran. I was hoping maybe the court might consider requiring him to get drug treatment through the VA and perhaps consider him for super intensive probation, maybe through drug court.
Sir,
Them with,
stop talking over your lawyer.
Yes, ma'am.
to maybe help him with his addiction issues.
Well, here's where I am. He was already on probation in 2018 for 2 offenses, a burglary of a building and a possession of a controlled substance. Went through the veterans program, including inpatient treatment referral, was revoked on both of those and received prison. The only way I will go along with this is it's going to be safety going into custody today. We're not taking, there's no reason, number one, on paper for him to really be eligible for probation. Your attorney's done a great job, but if you can't kick the habit, then you're going to get more than just outpatient treatment through the VA. That's already happened. So if, obviously any condition of probation is up to the court anyway, and so we can go forward at this time unless anybody has any reason not to go forward with sentencing.
I'm okay with proceeding now.
Okay, good.
I don't believe my client wants to proceed.
Well, so here's the thing, Mr. Street. The conditions of you've already agreed to probation. So any condition of your probation, outpatient treatment, just like Mr. Crenshaw is asking for, inpatient treatment, which apparently you don't want, those are all actually they're up to me. And so it's not really part of the agreement, and it's not something that I'm going to allow you to withdraw your plea over, because that's up to me. Anytime you're on probation, the conditions are up to the court and probation, what they feel is best. And in your case, if you're showing up to court after having had treatment and after having had 2 felonies already revoked, testing positive for meth, this is what I feel like is best for you and for the community to keep everybody safe. So at this time, in cause number 24, DCCR 2058, I'm going to find that you entered your plea previously freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of theft of property. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. I'm going to probate that. I'm actually going to change the length of time to 3 years, which is another condition that is up to the court ultimately. You will be required to pay the $6,000. Did you bring the $3,000 today? Okay, so the $3,000 was to be paid today, so that leaves $3,500 to be paid while you're on probation. As a condition of your probation, what I will do instead of SafeP is order that you enter and successfully complete the substance abuse track of the ISF program. It's still an inpatient in custody program, but it is a shorter one. You will be required to go through the JCDI program when you get out as your aftercare. And so if you do all of that, I don't even know if you realize what a big opportunity this is today. So your case, for all practical purposes, here in court is over if you do everything you're supposed to do. The other side of that is if you don't do everything you're supposed to do, you're going to be back in here and you're looking at the 2-year sentence that you've already agreed to. Do you understand?
Yes.
I'm going to hand you.
Judge, he does have a family. Is there any way that before he turns himself in for ISF, he could have a week or so to get his affairs?
No, not with the criminal history, not showing up testing positive for methamphetamines. Those do not stay in your system that long, which means he's done them very recently. So I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can speak with Mr. Crenshaw. Good luck to you, sir. I hope you take advantage of this.
Thank you, John.
Thank you. Thank you, Mr. Crenshaw. Good morning, sir. You are John. Is it Foret or Foray?
Boy.
Foret. And Mr. Foret has 2 cases, 25 DCCR 1458, charged with burglary of a building, and then 26 DCCR 0047, charged with criminal mischief. And what is the announcement?
Judge, on the newer case, the criminal mischief, we just repped it last week. We've done our tape request and everything. So I'm expecting that we'll get the videos in here pretty soon, but we'll have to have another court date.
Sure. And those are the same offense dates.
They
So
are.
initially it looks like there was a new offense after first one, but there was.
Same day.
Okay, just for whatever reason indicted sometime later. Any issues?
No, Judge, just, would the court possibly consider doing a drug test on him this morning, just to kind of see what position we're in?
Yeah, sure. If there's some issues that you want, me to check that, I will. Mr. Fort, have a seat in the jury box.
It
We're
may
gonna get the
help
drug
us
test this morning.
towards resolving if we know the result of
Sure.
that.
And this is Miss French.
I am standing in for Miss French on this room.
All right, sir, you're Duma Turner. And in cause number 24 DCCR 1998, Mr. Turner's charged with criminal mischief. Mr. Elmore, what is the announcement?
Judge, we would like one last announcement. There is a restitution issue in this case. It was Kobe's case the last time we were here. I do believe that they were able to look into that matter before he transferred the caseload. But it didn't help because there is no proof of restitution, it appears, in this case. So I'd like the opportunity to talk to Pam about it. I've never spoken to Pam about this case, and she's not here this morning. We may have to put on a trial docket, but I don't want to do that without talking to Pam about the case first, since it's going to be her case.
Judge, my position is, late last week, I did talk to Ms. French about this issue of restitution. We had our, she reached out to the complainant in this case, which happens to be a complex. They were either unable or unwilling to provide us with documentation as it relates to restitution. So my position is, Mr. Galmore wants to move this case and go forward with 5 years deferred. You know, that's where we are as far as.
But without restitution.
Right. They're basically maybe offering it without restitution. Not sure that we would even accept that necessarily, but I'd like to talk to Pam about it since it's going to be her case.
Sure. All right, I'll just do one more normal reset. Make sure you get in touch with Ms. French
I will.
before that next court date so we can get it taken care of one way or the other. Stay in touch with Mr. Galmore. He'll let you know when you need to be back. All right, thank you.
Judge, in this case.
Good morning, sir. Are you Robert McGrew Jr.?
Yes, ma'am.
Would you please raise your right hand? Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Galmore.
Are we? Judge,
Okay.
can we off the record real quick?
You want to hold us to include the church.
Just a second. Good morning, sir. You Kelby Blanchett?
Speak up.
Right. And will he waive the formal reading of the indictment?
No way.
Mr. Blanchett, in cause number 25 DCCR 0799, the state has elected to proceed on the lesser included offense of terroristic threat, a Class B misdemeanor, from May 21st of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablets and documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Blanchett is not competent?
Believe it. Sure. Evidence or everything.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this on your record and the conviction on your record. And at the end of the probation period, if you are successful, the case will actually be dismissed. You'll never have the conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced to jail for up to 6 months. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork, and she's sitting at that desk right over there. So watch for her to call your name, okay? Good luck.
Secure.
Good morning. Are you Wayne Cummings? This is 18-29640. It's a motion to revoke probation. And what is the announcement?
Furnace. There you go.
Judge, in this case, all the allegations are from, the arrest and pending case in Orange County. I think we draw up a list that we said it hasn't been brought to the Orange County District Attorney's Office yet.
Okay.
So,
Right.
I checked this morning. They haven't received it yet.
Okay. We'll just do a normal reset and see where we get at the next court date. Stay in touch with Mr. Kimler and your bondsman. They'll let you know when you need to be back. Okay.
I think for you, that's already. He has the GPS and wanted to work on it and most of it, I guess.
He can work with the GPS.
you know,
I'm not gonna, just based on what I know right now, the next court date, there, we'll see where we are if there's nothing with that one, but apparently that's had something to do with,
She hasn't put a restriction on having this up to what the bond conditions are.
Actually, she said the drive
Yes, she did.
was allowed.
All right, so you can't, that's a condition of your bond here that you can do.
so I think part of my concern was the time of the arrest was at 4:15 in the morning in Orange, which was, I don't think he had permission to be in Orange. So, let me try to look and see where. Here we go. I set a bond. Mr. Kimler sent something in. I set that bond and that have a GPS, cannot drive any vehicle, remain in Jefferson or Orange County,
Where are you working?
and have a handheld. Do you have the handheld breathalyzer? Okay. All right.
Where did you have in the house?
Where you can work, you can go to work in Jefferson, Orange County. So
You just can't drive. You got to get a ride.
But the job in the Tesla plant house, they hired me on.
He wants to work in Travis County, or.
Not until I know. No.
Okay, yeah.
I mean, you've got a case pending potentially in
Understand.
Orange, so let's get that one figured out quick and then we'll decide. Obviously, we want you to have a job, but we're not going to do that yet. Ryan Hodge, Mr. Kimler, it's the sentencing.
It's agreed.
My question is, did he plead to,
What did they want to do?
but did he, it says here habitual felon on the PSI. Did he plead to the,
Enhancements.
that's what, I think, if I'm going to take it, I'm guessing y'all did because of the
Yes,
criminal
we did.
history.
Yes.
So that if
But-
you violate it,
It
needs
would be
minimum 25. Got it. Okay, just wanted to make sure.
She's pretty important.
All right, sir, you're Ryan Hodge. This is 24 DCCR 1167. Mr. Hodge was previously in court, entered a plea of guilty to evading arrest or detention with the use of a motor vehicle, pled true to prior offenses, making this for punishment purposes a habitual offender punishment. The agreement was for a 10-year deferred probation, $500 fine. I received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Judge.
Defense agent.
Any additions or corrections?
No from defense.
Not mistake.
And again, the agreement was he pled true to those offenses so that if you violate this probation, the minimum punishment, if you are violated and you get found guilty, would be 25 years. Do you understand? There's no negotiations at that point. That is by law what the minimum will be. Okay. Your criminal history does not make me feel very good about you being successful on this probation. But if you've changed your life, this is going to be your opportunity. If you haven't, you're going to have a minimum 25. It's that simple, right? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. Obviously, you understand what a good opportunity this is if you are successful and you complete the probation. The other side, again, is if you violate any condition of probation, you'll be back in here, you'll have the conviction, you've already pled true to the prior offenses, and you'll end up with at least a 25-year sentence up to the rest of your life. It is important. You're going to be on the high medium caseload, at least at the beginning of your probation, and that's intended to help you, not hinder you. But we want to make sure you have everything that you need in order to be successful.
I think you live out of county?
Yeah, I live in Oklahoma. I have a great support system. I have another job.
They'll talk. You need to talk to probation about where you live, and they'll get it transferred to where you live. You just have to go through the proper process to get that taken care of.
A high medium caseload, whatever.
Yeah, whatever stipulations I have followed.
Yeah, I'm sure everyone has some type of more intensive probation, and that's what I'm going to order, whatever it's called in whatever county or state. There will be a substance abuse assessment done. If there's anything in that assessment that's done that shows that you need any type of treatment, you will be required to do that. Anything else that probation says, you're required to do it. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paper. Good luck to you, sir.
Thank you.
I'd like to leak your stuff for you.
Good morning. Are you Kyra Rogers?
No.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Rogers, in cause number 25 DCCR 0976, you're charged with the state jail felony offense of theft of service from June 5th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, no.
And are you pleading guilty because you actually did what they charged you with?
Yes, no.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, no.
And do you fully understand them?
Yes, no.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, no.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, no.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would not be a fine, but there would be restitution in the amount of $2,536. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Ms. Rogers is not competent?
No, Your Honor.
Any reason not to go forward in
No,
restitution?
I know you're on her record's clean other than this incident.
So I'm going to waive the pre-sentence report, Ms. Rogers. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow that agreement that you made with the district attorney. Defer all proceedings for 2 years. So you'll be on probation for 2 years.
Okay.
You're ordered to pay $2,536 in restitution and to follow all of the other rules and conditions of probation.
Okay.
If you do that, this is a great opportunity because you don't have a felony conviction on your record.
Yes,
And if you successfully complete the probation at the end, the case is actually dismissed and you'll never have that conviction.
okay.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty and you could go to the state jail prison for between 6 months and up to 2 years.
Okay.
You understand?
Yes, no.
Also, it is very important. 2 years seems like a long time potentially to pay off that money, but it's going to go by pretty quickly.
Okay.
I want you to start making payments immediately. Even if it's a little bit, it'll add up.
Okay.
Because what can happen is if you don't make payments on that, and at the end of your probation period, I find that you could have paid, you could do 2 years of probation and still be revoked for not paying it.
Okay.
So make sure you get that paid, okay?
Yes, no.
All right, if you, I'm handing you the trial certification that this was an agreement that I followed, and so you waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. She's at that desk right there, so kind of pay attention for her to call your name, okay?
Okay.
All right, good luck to you, ma'am.
Thank you, Your Honor.
Thank you. Mr. Parker, you have the sentencing on Allison Strong. Good morning, you're Allison Strong.
Yes, no.
And Ms. Strong was previously in court, entered a plea of guilty to assault on a peace officer. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Have your honor.
I have, Your Honor.
Are there any additions or corrections?
None of the way, Judge.
And I'm not staying.
All right, Ms. Strom, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to follow all of the rules and conditions of probation, including you will be on the mental health caseload so you can get whatever type of help necessary so that you can be successful on your probation. It's important that you follow all of the rules and conditions through the mental health caseload, through regular probation. If you do everything you're supposed to on this probation, it's a great opportunity because you don't have a felony conviction on your record. And at the end of the probation, if you're successful, the case is dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you become a convicted felon, and you could go to prison for anywhere in that punishment range, which is between 2 years and up to 20 years in prison. Do you understand?
Yes.
All right. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, watch for probation. She's going to call you up and she's ready to go over your paperwork. Good luck, ma'am. Yes, yeah, no fine. Mr. Parker, you got Lisa White.
Your Honor, I believe we're gonna,
Let's get Lisa White.
she's here.
In cause number 25 DCCR 0923, Ms. White is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I'm having issues with contact with the complainant. I'd ask for one reset. Well, been able to issue a subpoena and do a bailiff's call it that.
Okay, sounds good. We'll do a normal reset for that. Ms. White, stay in touch with your attorney, with your bondsman. They'll let you know when you need to be back. All right, thank you. You're free to go.
Thank you.
That note on the reset. So Mr. Foray tested positive for THC, cocaine, methamphetamines, amphetamines, and benzodiazepines.
Wow, that's not one failed test. That's a list of serious violations.
So obviously, there was some information that Ms. Malfino had that I did not as to why we should test, but there's something going on here. And that's clearly a violation of the bond in both of the cases. I'm going to find that you have violated the bond conditions in cause number 26 DCCR 0047. Raise your bond in that case. Let me see what it's set at. Give me just a second. Okay, what's the, thank you. So in 0047, I'm going to raise the bond in that case to $50,000. I'll go over conditions in just a second. And then the first one, do you have that one? Clause number 25 DCCR 1458. Raise the bond in that case to 25,000. Condition in each of those, a bond in each of those cases, if you make those bonds, is that you have a drug patch on at all times. You will have to have a drug patch within 24 hours of your release from custody. They get changed every 2 weeks. If they test positive when you get out, it's a violation, and obviously your bonds will go much higher. Do you understand?
Yeah, so.
Okay.
All right, you can go back with the bailiff. Morning. Good morning, sir. You Spencer Broussard?
Yes, ma'am.
And Mr. Broussard was previously in court and cause number 25 DCCR 1442, entered a plea of guilty to aggravated assault with a deadly weapon. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
Any additions or corrections?
Not from the defense, Your Honor.
Not from the state.
I guess I have a little concern because Mr. Broussard, you stated that this was all just a setup, which makes me a little concerned that you're not taking responsibility for your part in what you pled guilty to. And so it's important, obviously, if you pled guilty, I asked you some specific questions. If you're pleading guilty freely and voluntarily, and if you plead guilty because you did what they charged you with.
Yes,
So did you do what they charged you with?
yes, ma'am.
Okay. Any reason not to go forward?
No, Your Honor.
No, Your Honor. All right, then at this time, I'm going to find, Mr. Broussard, that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed and you'll never have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
I'm going to hand.
And that's the lesson from today's courtroom session. Some defendants earned another chance, while others learned how quickly that chance can disappear. One decision, one violation, or one failed test can completely change the outcome. Let me know in the comments which case surprised you the most.